company has right to borrow money. There will be instances where the company may be low in capital. It can decide to go and borrow money. The law permits it. But what now happens? There's going to be charge on the assets of the company, which can either be fixed, which means that there is collateral, or floating, there is no collateral. So where there is no collateral, which is the floating charge, the right that the creditor has over the assets of the company, it means that they can agree that, okay, this charge will be on all the assets of the company or a part of the assets of the company. If they have also looked and examined the situations of the company and they feel that, okay, presently what this company has is capable of satisfying this loan, they can cover the charge on only the present assets of the company. But when they have assessed the situation, they know that, okay, what this company presently has cannot satisfy this debt, we have to extend the charge to the future assets of the company. The fact that a company has gone ahead to borrow money and the creditor has charge over the assets of the company does not stop the company from continuing to use their assets or their properties, their cash, as the case may be. They will continue to carry on business. The outside world does not know that the company is in debt. But where it now becomes enforceable, it has now come to the point where the company is supposed to pay. It is due for the company to pay, and the company is unable to pay. It means that the creditor that has charge over that asset, over those floating charge or fixed charge of that company, can now exercise his right. What it means is what he can go ahead and appoint a receiver that will help him in the process of recovering his money. But where he's also unable to appoint a receiver, it means that the court will take steps to appoint a receiver. So some people will ask, what will now be the position where a company has assets, it has borrowed money and has both fixed and floating charge? Which one will now take priority? Karma says that the fixed charge will take priority, but there is exception where the person who is now subsequently creating charge on that property or assets of the company is aware that there is a floating charge already subsisting with respect to the assets of that company, and there is a notice that has made provision that, look, no further charge should be created on the assets of this company. And if the person who also created that prohibition has taken steps to register that notice with Corporate Affairs Commission, it means that a subsequent charge on the assets of that company will never take priority. This is Xivial Law Essence. Here we give you premium legal tips to help you make informed decisions, live informed life, and